By way of introduction, I'm Barry Anderson. I'm an Associate Justice on the Minnesota Supreme Court. Had the privilege of judging this competition, but I also had the privilege years ago of serving as an assistant coach, so I have some idea of the stress you're all under. We're looking forward to having a great conversation today. Sarah?
I'm Sarah Kirk. I'm a professor emeritus from a state college in Nebraska.
And I'm Mike Miles from Birmingham, Alabama. We were talking about accents out in the hall, and I'm very glad I don't have an accent.
Yeah, the standard line in Minnesota is we don't have any accents either. Yeah, sure, you betcha. That's
You
true.
betcha.
Yeah. All right, so if you'd be so kind as to introduce yourselves, briefly introduce yourselves and your faculty advisors, coaches, and whatnot.
Hello, my name is McKay Garvin, and my favorite president is George Washington for the way he set norms and defined what it meant to be the president.
Hi, my name is Horatio Kahn, and my favorite president is Franklin D. Roosevelt for the work he did to rebuild America during the Great Depression.
Hello, my name is Bryce Thompson, and my favorite president is Lyndon Johnson for his determination in forwarding American progress towards a great society.
Hi, my name is Julia Stan, and my favorite president is Dwight Eisenhower because of his support of science by signing the act that started NASA. And on behalf of Unit 4, our advisor Gretchen Wolfing, Tahoma High School, and the great state of Washington, we thank you for judging us today.
Well, we're delighted to be here. And no surprise, we're here on Unit 4. How the values and principles embodied in the Constitution shaped American institutions and practices. And equally no surprise, we're here on question 1. Legislative power in Congress changed significantly from the Articles of Confederation to the Constitution. Why do you think the framers felt it necessary and or proper to add the necessary and proper clause? How has Congress used this constitutional power in legislation? How have the courts impacted that power? How does the listing of enumerated powers affect the impactfulness of the concept of implied powers? If you're ready, we're ready, and we look forward to the conversation.
The national government, like every other, must judge in the first instance of the proper exercise of its powers. Alexander Hamilton.
In the final Constitution, the necessary and proper clause was added by the framers to give Congress the authority to create essential laws as the demands of the nation evolved.
The necessary and proper clause concludes Article 1, Section 8's list of 17 enumerated clauses that outline Congress's enumerated powers, with the general statement granting Congress the power to make, quote, all laws that shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested in this Constitution.
The necessary and proper clause was added to the Constitution in response to the shortcomings of the Articles of Confederation, which limited federal power to only those, quote, expressly delegated to the United States, end quote. The clause provided a sense of elasticity to the written document, allowing the legislative authority of Congress to be stretched when necessary.
Furthermore, in Federalist 44, James Madison stated, quote, without the substance of this power, the whole Constitution would be a dead letter, end quote, implying that without this clause, Congress would have no means to create legislation to carry out the ideals of the first article. This further emphasizes the importance of the necessary and proper clause in the Constitution, as Congress relies on it to pass appropriate legislation for a rapidly changing America.
From the very beginning, the courts have been instrumental in impacting and defining the powers of the necessary and proper clause. The issue was first brought to the Supreme Court when Congress established a national bank, and the states argued this was beyond the powers of Congress. In the 1819 case McCulloch v. Maryland, the state of Maryland claimed that the chartering of a national bank on state soil was unconstitutional. The court ruled that under the necessary and proper clause, Congress had the right to pass any laws that further the objectives of their enumerated powers.
In the Chief Justice John Marshall majority opinion, he stated that in the clause, the term necessary meant, quote, appropriate and legitimate, giving Congress the power to make whatever laws that they feel is necessary to meet the needs of an ever-evolving country. One example of this being in 1965, when Congress felt it necessary to provide health care. They passed the Medicare and Medicaid Acts for elderly and impoverished Americans.
As time passed, however, Congress decided it would be beneficial to provide more affordable access to healthcare due to a rise in the cost of healthcare in America. And so, Congress yet again utilized the necessary and proper clause to pass the Affordable Care Act of 2010. These pieces of legislation showcase how Congress continues to evolve in response to changing times and how the courts have validated Congress's use of the necessary and proper clause in order to provide solutions for a more modern America.
Through the listing of enumerated powers, Congress has been able to expand the powers explicitly given to them in the Constitution, molding its express powers into implied powers to achieve the needs of the nation. For example, as numbers on violence crime doubled between 1980 and 1990, Congress felt it necessary to pass legislation on gun control, namely the 1993 Brady Handgun Violence Prevention Act, which mandates background checks to be completed before a gun is purchased.
To justify the act, Congress cited Article 1, Section 8, Clause 3, which gives it the power to regulate interstate commerce. While the Commerce Clause does not explicitly grant Congress the ability to regulate gun sales, the necessary and proper clause is the means by which actions like it are justified as implied powers expand upon enumerated powers.
Furthermore, Congress has expanded upon the power to, quote, establish a uniform rule of naturalization, found in Article 1, Section 8, Clause 4. They have done this to legislate on immigration, such as the controversial Chinese Exclusion Act, which banned the migration of all Chinese laborers to the U.S. In the 1882 case, Che Chen-ping versus United States, the court ruled that this act lied under the constitutional powers of Congress.
The listing of enumerated powers positively impacts the effectiveness of implied powers because the necessary and proper clause can mold any and all enumerated powers to satisfy the demands of the nation as it evolves. Thank you.
Very good. How has the necessary and proper clause, as we have grown from 13 states to 50 states, obviously, we often talk about how it started off as dual federalism, maybe a little more cooperative federalism. Have we gotten to the point where it's just conflicted federalism, that nobody knows who's in charge and we point the fingers at the other level?
I would not say. I think we do have clear bounds of federalism set by our amendments. In the 9th and 10th Amendment, we say that all rights not given to the federal government are given to the states and the people. And so I believe this provides a great groundwork of where rights rule when it comes to federalism.
Sometimes it's hard to tell what branch is truly in power because each branch has a version of the necessary and proper clause. The president has the take care clause in Article 2, Section 3, which gives it the power to pass executive orders and memorandums. Well, the Supreme Court and the judiciary branch as a whole has the power of judicial review established in Marbury versus Madison.
You mentioned the word expressly. If you look at the 10th Amendment, that word is not there. It just says all powers not delegated are reserved to the people in the state. So what's the difference between expressly delegated and delegated, and how does that play into necessary and proper?
I believe this all comes back down to the fundamental concept of enumerated versus implied rights. We have certain enumerated rights in our Constitution, such as Article 1, Section 8, Clause 4, which is the power of Congress to be able to establish naturalization and citizenship. And so this eventually comes back to the fact that these implied powers that we have and the enumerated powers expand on one another in that certain way.
Thank you.
Not to let McKay off the hook because George Washington, as Professor Crook said, didn't have the benefit of time to watch and see how things evolve. But he can play if he wants to. Is what would your favorite president, or FDR, generalized now? Would they think we've got it about right now? That we've got federalism about right, or we give the states too much power? Would they think we're giving the states too much power?
When looking at President Johnson, I believe that he'd be disappointed with how the federal government has expanded. President Johnson, under his Great Society legislative agenda, drastically expanded the powers of the government by passing Medicare, Medicaid, by passing the Civil Rights and the Voting Rights Act. President Johnson was all for giving people rights while also helping them through things such as the war on poverty and his battle to increase welfare. I think President Johnson would be very disappointed with how presidents such as Ronald Reagan have contracted his agendas so then they haven't worked in their entirety.
I think that President Franklin D. Roosevelt would be pleased at the state of federalism today, and I think that especially him being the president during the Great Depression would understand that in times of war and emergencies, the federal government should take more hold than state governments because we as a nation need to be under one agenda so that we can get through a certain war or a certain emergency like the Great Depression years before or more recently COVID-19.
Yeah, FDR was known to expand the government a little bit.
Let me ask you about the structure of the necessary and proper clause, and I'm wondering if it's become too powerful. What checks do we have to control the expansion of the federal government under the necessary and proper clause? Maybe we shouldn't have any checks. I mean, that's an answer too. But I'm wondering, is there a way to control that power? You look at education. You look at a variety of previously considered to be local kinds of things. And we have federal healthcare, as you mentioned. How do we check the power of Congress?
In the ratification debates of the Constitution, the anti-federalists were enraged at the necessary and proper clause. Thomas Jefferson said that we would never know truly the bounds of this power. But he also said that if the Congress was to exercise unrighteous dominion over this power, it would up to the judicial and the executive branches to stop it. I believe that through the power of judicial review established in Marbury v. Madison, that this is the best way that we can check the necessary and proper clause and make sure that Congress is exercising its assigned constitutional abilities.
To add on my colleague, an example of the judicial branch using the power of judicial review to check Congress can be seen in the 1935 case of Schechter Poultry Court for the United States, where the Supreme Court struck down portions of the National Industrial Recovery Act, which gave President Roosevelt, who was trying to regulate the economy through fair practice codes, they struck this power down.
I believe political parties can actually check the power of Congress itself because, as we can see in our government right now, the House of Representatives has a slight Republican majority, while Senate has a slight liberal majority. And when you compare these two, if the House of Representatives tries to pass a bill, the Senate can decide not to pass it, and this would stop a bill from being passed, which could be a check on the necessary and proper clause itself.
And adding on to my colleague Julia's point, I think not only political parties, but the makeup of Congress as a whole can act as a check on the ability in which they can pass the necessary and proper clause. In Federalist 15, Hamilton mentioned that the passions of men cannot listen to logic and reason without restraints. And so I think that the deliberative nature of Congress and how acts must pass the House and Senate itself acts as a restraint because of the amount of discourse that they have to do and the amount of going back and forth that Congress needs to have with each other before they are able to actually pass and act on a necessary and proper clause.
So I would follow up with this question. Has our society become so mobile and people moving across, you used to be born and died in the same county, but not anymore. People move all the time. Technology, that's available. Should Congress be able to use the necessary and proper clause to standardize more things across all state lines that traditionally have been left to the decisions of states? I mean, have we gotten to that point in the 21st century that the necessary and proper clause should be even more elastic?
I do believe that the issue of immigration right now is a big issue, especially concerning the southern states of our America with the border of Mexico, because they are facing the brute force of immigration right now. And Congress could use the necessary and proper clause to help relieve these states of the current mass groups of people trying to move across the border, or make more enforcing restrictions over how to legally pass and kind of hammer down on those who are illegally passing our government, because they are really impacting our southern states.
I would like to respectfully push back on your point and say that I would argue it's more of the Commerce Clause that Congress would be using, found in Article 1, Section 8, Clause 3, to regulate this commerce. We saw in Heart of Atlanta Motel, the U.S., that Congress had the power to enforce the Civil Rights Act through the Commerce Clause. So I would argue that Congress did try to legislate to try to regulate where people are going. It would fall under the Commerce Clause and not necessarily fully under the necessary and proper clause.
In addition to my colleague, scholars have also pointed out the concept of the dormant commerce clause, that while the federal government can regulate interstate commerce, states cannot affect interstate commerce amongst themselves, as seen as the case on National Pork Farmers of America v. Ross, in which they ruled that California could not regulate pork sales based on reasons of animal cruelty and morality.
I see your immigration problem, those blooming Canadians won't cross over to Washington. That's a real problem that you have to fight all the time.
That's a problem on our northern border.
On Minnesota, that's right, exactly. I hadn't thought about that.
Crazy Canadians, it's a real problem.
Fighting all the time, crazy Canadians. So if you're right on some of these things, the federal government stands by and lets the voting rights in my state be very much more restrictive than in yours. If the right to privacy of young women in my state is more restrictive than it is, say, in Illinois, if the criminal penalties in my state, two cousins do the same crime and one serves 15 years in Illinois and one's put to death in Alabama, has the Constitution's promise to me and to you of equal protection under the law become a hollow promise because of how much they let the different states discriminate against us?
I do believe it can become a hollow promise because under the 10th Amendment, we see that rights not given to the federal government are given back to the states, which means these states can decide how they want to go about regulating stuff that can be seen as discriminatory. So I believe it is really up to the states that decide, not the national government. And if states decide that they want to act discriminatory towards their citizens, people can vote in new representatives and vote in new senators who would represent themselves better in the national government based on what they want to see in the national government, but also their more local representatives in their state government.
I would argue that this brings back to federalism. When we have the equal protections under the law, it was meant to encompass all rights and all freedoms. But what we've seen is that when the Supreme Court, such as the case Dobbs v. Jackson, throws these issues back to the states, we have very different protections under the law. We have seen that in states such as Alabama, a woman's right to choose is a lot more restrictive than it is in our home state of Washington, where it was recently enshrined in our state constitution. We have seen that because the Supreme Court is throwing back these issues, it is bringing back up federalism and states' rights versus the national government.
And while this is a hollow promise and has the potential to be very disastrous, I believe our federal government is working to protect this, as seen with the Respect for Marriage Act that has recently been trying to push through, in which they can codify rights such as the right to same-sex marriage that is has a potential to be taken away in the overturning of Roe v. Wade decision. Clarence Thomas pointed out in his opinion that they could possibly look at rights such as these, and by codifying these rights in legislation using the necessary and proper clause, we can best hold true the promises of liberty for all.
I wouldn't say it's a hollow promise at all. The federal government can only go so far as to standardize a set of laws throughout the nation.
Well, they obviously agree with you.
They can only go so far to standardize these set of laws because
Finish your thought.
America is so expansive and we have so many different cultures in different parts of the United States, and so people in different states have different values and things that they'd like to uphold.
All right, very good. Learn something every day. Sarah, you want to go?
Yeah, thank you. You're quick on your feet. Particularly your comment back at me that it was more the Commerce Clause. I was like, very good, very good. I love that you brought up the Heart of Atlanta Hotel case. That's an excellent example there as well, because it was decided on the Commerce Clause, although I believe it was the dissent that said it should have been decided on the Equal Protection Clause. So, I love many of the points that you brought up. I love that you brought up that the president has the take care clause, that obviously is kind of his or her necessary and proper clause, if you think about it as well. And of course, the Supreme Court with judicial review. I thought it was very balanced. I thought you were very articulate and concise, which is good. So I would just have to say that this whole process, you included, has recalculated my hope for the future, and I just hope we clone you all.
Mike?
Yes, sir. When I was a student at Birmingham Southern, there was a barbecue place near the campus called Ollie's, and they would not let black people eat there. We weren't very conscious of that, being 18 years old at first. And then the McClone case hit with the interstate commerce, prohibiting them from being able to be segregated if they were transporting their goods and services from state to state. And we all quit eating there because of that. And we hated the McClone case because we had really liked eating there. But that case made us feel that's not a place for us to go. Judge, my only thing I'm sitting here thinking right now is, if I move from my state, from Alabama, and get to move to their state, are they going to consider that an immigration problem? Or it doesn't matter, I'm coming anyway.
Yes.
Love that, you
It's not just the crazy Canadian.
That's right, it's the crazy,
Alabamian?
Southernites. That's right.
Alabamian?
Alabamian.
All right, very good. So I thoroughly enjoyed the conversation. Some things that I just picked out generally, I appreciate the citation to the Chinese Exclusion Act, one of our finest hours, to say the least, but certainly relevant to this question. I really liked the response where you talked about the other ways in which the other branches participate, executive power, judicial review. I thought that was particularly useful. the reference to the Anti-Federalists. But it's probably a good thing the Anti-Federalists lost the ultimate debate. It's a very good thing that they won on the Bill of Rights. And I think the Anti-Federalists will be thoroughly appalled at the way the necessary and proper clause is interpreted today. I want to particularly call out your reference to Schechter. We don't pay much attention to that case these days, but that was a 9-0 decision by the Supreme Court. And if you read what they were doing to those poultry business owners, it really is an interesting, well, I would call it abuse of federal power. That you've got my biases now. But to cite that here in the context of the necessary and proper clause, one of the issues it creates for all of us is it's much easier to, if I have an issue with my local city council, I can go to the city council. If I have an issue with a federal law, who do I go to, and how do I deal with that? It's a much more difficult proposition. It's the other side of the point that Mike was making, excuse me, Mr. Myers. But it's the other side of the point he was making, which is, what if they're not enforcing your rights? But there's another side to that thing, and I think you recognize that. So yeah, I thought it was a very strong performance, and I appreciate the opportunity to be with you here today.
I should be able to be up there by Monday or Tuesday. I gotta go home and get my stuff.
Make sure you look up to Homa High School in Maple Valley.